Good morning.
Hold on one moment, please. All right, thank you. Yes, sir.
Good morning, Mr. Chief Justice, Justice of the Court. May it please the Court. My name is Steve Nyman. I represent Mr. Alex Morales on appeal. I did not represent him down below. There's a few issues that are in the brief right now. I really only want to focus on one to the extent we can. I think it assumes the majority of the legal issues in the brief, and that is the issues relative to the motion to suppress my client's various statements. Just sort of as a backdrop against this, if I could, I just want to go through a few of the facts with the Court just for the purpose of chronicling what happened. On December 8th, around 2007, around 2 or 3 o'clock in the morning, the victim in this case, Corey Lind, left to make his last pizza delivery. He didn't return, and shortly thereafter, a detective by the name of Cass became involved and learned that Mr. Morales had made some delivery requests. About 10 p.m. that day, so we're going forward about 20 hours, Detective Cass goes over to Truman Circle, which was where the defendant had been known to stay at times. He had friends who lived there. The detective meet up with my client. They ask him to empty his pockets, put the keys on the car, and at this time, Detective Cass knows that Corey Lind, who's missing, had a Chevy Lumina, and he sees that the keys are General Motors keys. They get to the police station about a half hour later. That's 10:30 on the 8th, and Detective Dean meets with Mr. Morales along with others, and that's really starts around 11. And at that time, Mr. Morales is confronted with the fact that they believe that he has the victim's keys, and they're going to go over and see whether or not it fits the car. And then Morales, at that point, admits to finding the car. At 12:22 in the morning, so now we're a few hours farther down the road, and now we're on December the 9th, there's a tape-recorded interview of Mr. Morales. It concludes 3 hours and 38 minutes later at 4 o'clock in the morning, and shortly after that he agrees to go show the officers where he finds the car. They go on a particular route, which and the ride lasts about 2 to 3 hours. They then get back to the station, and Mr. Morales is asked if he wouldn't mind staying around for a while. So this is getting us to 7, 8, 9 o'clock in the morning. Detective Dean then learns from another officer, Detective Kervick, that he finds a pair of bloody jeans at Mr. Morales' home on Massasoit Street. Mr. Morales is then confronted with the evidence, and he starts to cry, and then decides he's going to give another taped interview. This one starts at 9:53 in the morning now, and it ends at 1:35 in the afternoon. Then Morales tells the police, obviously, a story during the course of that interview. Detective Dean has been up for about a day and a half, so he goes home to get some sleep. In the meantime, Mr. Morales is intermittently put in a cell. His clothes are taken from him. He's shivering, and he's confronted with information that his story lacks credibility. Later on, he agrees to give another recorded statement. That's 9:01 a.m., and it ends at 1:55 p.m. And now
we're on the 10th now?
We're on to the 10th. We've gone on to the next day. I apologize.
Was it? Didn't it end at 10:55 in the morning?
I have 1:55 p.m.
In the afternoon? So long.
Unless my
Okay.
well, many of these statements were 3.5 to 4 hours.
Okay.
I may stand corrected. I apologize. I'm reading from my notes right now, and it does get slightly confusing at times as you keep going forwards. I can refer to the.
Well, but it's the fourth statement. Third or fourth?
The one Monday morning.
The one Monday
Yeah, okay.
morning. Then later on Monday, Mr. Morales agrees to go with the officers to help locate the body. There's some discussion as to whether or not he offers this or he's asked to do it. Nevertheless, around 2:45, that happens around 2:45. It involves Detective Dean, Detective O'Shea. There's other detectives are involved. The Monson police chief becomes involved as well. And during the course of their travels, a call comes in to the officers, letting them know that counsel has been appointed for Mr. Morales. According to the testimony of the officers, he declined having any intention of speaking with him or desire to speak to him. There's also the issue, and let me first apologize to the court before anything else. In my brief, I make mention, I relied on, Detective Dean's statement that my client never signed the Rosario waiver. The documentation I had in my file did not indicate that he did sign the Rosario waivers. He did, in fact, sign the Rosario waivers on 2 occasions. I think it was 9:05 and 10:05 in the morning on the 10th. It slightly changes the analysis, but certainly doesn't change the issue to the extent that we're bringing all the coercion and lack of voluntariness forward, not only as it pertains to the statements Miranda waiver, but also as to the Rosario waiver. And I do apologize for that, but what I took was from the trial testimony and the documents that I had. And when I was provided with a copy of the court file, that wasn't there. Counsel did provide me with copies, and there's copies in the brief, so that was, in fact, signed. I also want to let the court know that an attorney was appointed and went over to the Detective Bureau at 2:48 in the afternoon ended up speaking with Captain McFarland over at the Springfield Police around 3. McFarland made clear that there's only 4 hours of daylight left, and they were not going to bring Morales back. His efforts were focused on getting out to the body. There's really 4 issues that fall under the umbrella of these facts. The first is when, in fact, Mr. Morales was in custody, and then when he would be entitled to his Miranda warnings.
Now, he got the first Miranda warnings about 12:27 a.m. the first evening, right? Or he was brought in at around, and they started questioning about 11, and then he was given Miranda warnings at about 12:27.
He was given Miranda warnings then.
So it's really only that period of time that we're talking about.
He's given the warnings then, but I think the other analysis is whether or not he felt free to leave regardless. And the reason I say that was because he was essentially, the officers during...
Are we talking about any longer a period of time then than 11 to 12:27?
I am. I'm really going to earlier the next morning.
But
What would
he
he
got
been a Mir-
Miranda.
He did, well, he did get the Miranda. I don't doubt that. I think there was some, well, let me backtrack a little bit. We can just at least start with that 3-hour period as to whether he was in custody at that particular time and whether it's...
11 to 12:30 is an hour and a half.
That's correct. And at that point, he was the focus of the investigation. The officers knew that the pizza request or that somebody with his phone who was identified as being over at Truman Circle had made these calls. They knew that Corey Lind had a Chevy Lumina. When they searched Mr. Morales, they found...
Is it what they knew or what they told him? That counts.
I believe it's what they knew at the time. It's the information they had. And
Well, all they knew is that he had at the time he was coming into the police station to talk to them, that he had a set of keys for a Chevy Lumina, and that the victim owned or drove a Chevy Lumina. The only other thing they knew was that they were investigating a missing persons report. There was no idea that there had been a robbery or a murder.
no.
I'm wrong?
No, you're absolutely correct about that.
They didn't know at the outset of their questioning that he had the keys. Didn't that come from somebody else a little bit later?
Came from the backpack when they searched him.
No, it came from Cass. When Cass was driving him, he emptied his pockets on the hood of Cass's car.
Right.
And he saw a knife on the hood of the car, and he saw some car keys.
That wasn't when he was driving. That's when he came out of the home at Truman Circle, and it was put on top of the car.
When he first, before
when-
he ever went to the police station.
Yes, that was when he first encountered him.
But
Now,
the
those keys-
interrogators didn't know that, did they, at the time?
Yes, Cass, the police detective who drove him from Truman Circle to the police station, knew he had keys, right?
Yes,
And Cass communicated that information to Dean, who was interviewing the defendant.
yes.
And it was only a matter of minutes before Dean asked him about the key.
Correct.
Did the police know that there had been several phone calls for a pizza delivery?
I think they knew that there were 2 phone calls anyway. One of them was to a fraudulent address, and then one was to an address that wasn't, that was a real address. And
And-
that came from the same phone, and that was traced back to Mr. Morales in Truman Circle.
The keys were just generic General Motors keys? Did
They
they
were-
say something on them that said Lumina, or any way that, it was
No,
just-
they didn't, and I should have addressed that with Justice
Well,
Spina.
Cass was a
mentioned that.
mechanic, and Cass understood that they were Lumina keys.
Yeah, I don't think there was any, well, from what I gather from reading the transcript, I don't think there was any doubt that these were Lumina keys, and that they certainly had.
But it came out early in Dean's interview with the defendant that the victim had a Lumina, and the defendant had the keys, and Cass asked him to explain it, and he said, "Yeah, I saw the car, and I took it for a ride." And at that point, he got the Miranda warnings, and they asked him to do a video interview, and that's when the video interview started.
That's correct.
So why is it not appropriate, once they had information from him that indicated use without authority, to then give him Miranda? That was the first time that they had information of a crime that was more than
That is
suspicion.
that is the time that is the time that it's supposed to be given.
So,
And wasn't it given
What's
then?
wrong with that?
I don't think there's anything wrong with that.
So you're not arguing he was in custody at the time they first took him to the police station?
I am saying that he was in custody at the first.
On what theory?
Well, on the theory that they had a missing person, that there was suspicion of some sort of foul play, that they had him as a target of this investigation early on from the 2 calls on the caller ID over at the pizza place, that they had gone right to his place and nobody else's place. They had immediately performed a search of the backpack, and that when he had emptied his pockets out, they had found the keys. And right then and there is where the suspicion certainly should have caramelized.
But I thought that they didn't really search the backpack, or they didn't empty his pockets. There was only one officer who was concerned about his own safety and said, "Do you have any weapons on you?" And the guy said, "Yeah, I have a knife." And he took it out and put it on the hood of the car.
Right. Yeah, I don't
I mean,
dispute
Cass had no idea that there was anything amiss, did he? When he drove the defendant from Truman Circle to the police station? Just asked him to come down. The defendant said, "Yeah, I'll come down."
I don't understand amiss in terms of what, and I apologize for I'm not trying to be.
It strikes me that there's really, the police are only investigating a missing persons report, and they knew that the defendant had called Domino's Pizza, and they asked him if he would come down to the police station and talk to them. It happens all the time.
Well, I would argue that in the context of this case, they had more, they believed more, and he was certainly much more of a target in that regard, and that the minute that he was placed into the car, that was the end for him. He wasn't
Target of
going
what?
anywhere.
A murder?
No, but
Armed robbery?
I don't know. They didn't have either one of those things, and they just had a missing person and him with a set of keys that likely would have fit the car that the missing person had that evening. And
So
that's
it's your position they should have given the Miranda warnings at that point?
right away.
But could you go to the end? Are you saying that cumulatively Miranda warnings given, Rosario given, it's just the fact of all this time with the cold and the probable lack of sleep, et cetera, that you can't say, that it's voluntary? Is that what you're saying?
In the final analysis, yes, and I know that I did lump 4 different things together here under the umbrella of the judge's failure to, or refusal to allow the motion to suppress the statements. But yes, it is a totality of the circumstances analysis that would commence around 10 o'clock or on the 8th and continue right up until the time that, that the body was found and the communication ceased. And the farther you read through the transcript and understand what happened here, it does become pretty apparent that they weren't going to, the police were not going to stop. They were not going to honor his rights. They were not going to surrender him even to his lawyer or the courts until they found their body.
Well, they did give him a cell phone to call the lawyer, didn't they?
Yeah, except they did give him a cell phone to call the lawyer, except they had never told him what the lawyer had said, and that's that he wanted the questioning to cease. They had merely told him, here, you've got a lawyer. If you want to talk to him, go ahead.
But
and
it
give him a
sounded
call.
like, from what I read, but maybe I'm wrong, that the lawyer agreed that whatever the message was, that the officer gave to the defendant the message that the lawyer agreed was the one to give.
I don't think that's completely accurate. I know that's mentioned in counsel's brief, and I don't say for one second that counsel was attempting to mislead this court, because I don't believe that. But I think that was taken out of context as to what Attorney Brown said during the hearing on the motion to suppress. And there really wasn't this suggestion that he said, okay, if this is the way it's going to be, then that's acceptable for now. I think what's clear is that he made his point. I'm representing this guy. I want questioning to stop. I'm not agreeing to you question him anymore. I want you to put me in touch with him. And the police were pretty much saying, we're not going to do that. Or at least Officer Goodrow, who was the officer at the station, I think was sort of delaying things a little bit. McFarland at least was very clear to him and said, we're not going to do this your way until we find a body. There's only 4 hours of daylight left. And the message was never articulated to Morales that Brown tried to get out to him, and that is stop talking.
Now, let's assume you're right, and let's assume there was a McNulty violation. Apart from the discovery of the body, what fruit was there from that violation?
Whatever else was found over in Monson that would be used. There were other pieces of evidence.
So not any further statements of the defendant, just the body and whatever evidence was found in or around the body?
Yes, and I think that's what the Commonwealth is pointing out in its brief, but I'm asking this court to go a little bit farther and say, when you take a look at the overall picture and everything that was done all along, this is just another factor, a series of factors in the analysis that seem to suggest wrongdoing and a violation of Mr. Morales' rights. And it's a continuing process that starts at 10 o'clock on the 8th. It doesn't end until very, very late in the day on the 10th, and he's not arraigned until the 11th.
The suppression hearing was an evidentiary hearing.
Yes, it was.
What do we do about the judge's findings of fact?
Well, I think, there is a transcript, and we're not necessarily talking about credibility issues here per se. We're more or less talking about factual issues that can be followed chronologically. And
Except that the judge, isn't the judge essentially saying that, look, the police officers did what they were supposed to do all along. They don't appear to have any kind of a motive to railroad this guy.
in terms of, well, you can certainly, this court can certainly make findings based on the record. And this court obviously is charged with reviewing whether or not his factual findings accorded with the law. And
So I say, when we do our constitutional analysis, it's going to jump off the page at us that something terribly wrong happened here.
well, jumping off the page, it's not the expression that I would use in this case. I mean, it does take, it happened over the course of 2 days. No, I wouldn't say it would jump off the page. I think you really have to read it very closely to understand what happened. I think Attorney Black did a very good job of exposing this during the relatively protracted hearing on the motion to suppress, he was able to get all this information out and able to really show the trial judge and the motion judge exactly where all this wrongdoing occurred. And I don't, for the most part, the judge's facts do parallel the transcript. It's more a challenge to whether or not he made a proper legal application to the constitutional challenge. And to the extent that there are any variations in fact, it's clear and been pointed out in the transcript. But in terms of credibility, that's not something I'm asking this court to evaluate. I don't believe it's this court's position to evaluate that.
All right, counsel, thank you very much.
Good morning. May it please the court, I'm Marcia Julian with the Hampden County District Attorney's Office, representing the Commonwealth today. Excuse me. There is one circumstance that I think is an overriding circumstance that I'd like to, kind of set the stage with right at the outset, and that's that the defendant agreed to and participated in 3 video recorded statements that the motion judge had the benefit of viewing in addition to the testimony at the hearing and the exhibits, and that the jury also had the opportunity to view.
But wasn't there evidence that the defendant was in a cell in between some of these statements and he was shivering?
Well,
trembling?
On Saturday, I think that the time frame is important. Saturday night, he meets Detective Cass around 10 in the evening, and I won't go...
That's the 8th? That's December 8th?
The 8th, I'm sorry. That's Saturday night, the 8th. Shortly after midnight Sunday, now it's Sunday morning on the 9th, he gives his first statement. He goes out with the detectives to locate where he claims he found Mr. Lynn's car. He's returned to the station. He agrees to stay and talk. He's then confronted with the evidence of the bloody jeans that's in his apartment. Now, of course, by now he's already been Mirandized. He makes an admission. He's re-Mirandized. A second statement is taken. And then, excuse me, after the second statement is taken, he decides he's not interested in going out and assisting the police further. So he's under arrest now. It's Sunday night into it's Sunday night in the, I think it's noontime on Sunday, excuse me. He's put in a cell, and that's where he complains about the cold. Now, because at this point, after his arrest, his jacket is taken because of the blood evidence on it. There was a legitimate reason for preserving that evidence.
Did they give him a blanket?
He had a paper Johnny, I believe. No, there's no evidence that he had a blanket.
So he's wearing a paper Johnny and he's shivering, and it's...
Well, it's Sunday
December.
morning. It's Sunday morning when Detective Dean comes in to see him in the cell block that this is the evidence, this is the only evidence where he is seen shivering. And he takes him out of the cell block and into an interview room. Now, I make this point because a third interview is taped. And the judge is in a position to judge the defendant's demeanor during this third statement. And he's not persuaded that the circumstances of his detention were coercive and affected his decision to confess to the crime, or that the police used any of these circumstances. The fact that he'd been held overnight, he might have been cold. He was offered food.
Is there some penological reason why they don't give blankets?
No, I don't believe that there's any evidence of that, Your Honor. And I don't know whether or not, this was brought to anyone's attention. I just would suggest that it was more or less the defendant's self-serving argument that Detective Dean happened to say, yes, he was shivering when I came in and I took him out of the cell block because the cell block area is cold. By now, he's made 2 statements. He's implicated himself in a crime. He hasn't fully confessed yet. So I would suggest that the evidence that he was cold is but one piece of the evidence, and the judge had the opportunity, as I said, to make those determinations based on the videotaped interviews, and it's something that this court can do as well.
Can I ask you, why is the cell block cold?
I have no idea. I'm sorry. I think there was some reference to the fact that it's in the basement, and it may just be like many basements. It's just cold. But he didn't complain to anybody, and the judge found that specifically. When he gave the third statement shortly after being taken out of the cell block, he was composed. The judge found that. He didn't complain about his conditions. So I would suggest that to some extent the claim is self-serving. It's not supported by the record. And it certainly is not of egregious nature. At least the record doesn't support that his will was overborne by his discomfort. And the judge finds also that his emotional state, it wasn't until he was confronted with inconsistencies in his statement that he cried, and that the emotional upset was abbreviated. He composed himself. And I think that is why I mention this as an overriding type of circumstance that's so compelling, is that the video says a lot. And the judge, based on that, the judge made these findings of fact that are not subject to review by the court and applied them correctly to the law. Now, insofar as the initial period, and as the judge found, Miranda warnings were not required, but Detective Dean gave them, notwithstanding when the defendant said that he had found the car and taken it for a ride. At that point, the police were investigating what they considered to be a missing person investigation, and they had no idea what, if anything, had happened to Mr. Lind, whether or not the car had been loaned to the defendant, or what the circumstances were surrounding that. So there was no criminal investigation ongoing at this point. As soon as he made that statement, I think the testimony was Detective Dean said, "Time out." He said, "We're going to give you your rights here and ask if you mind being videotaped." The defendant was agreeable throughout, and it's clear that his will was not overborne, that he did everything voluntarily. He knew he wasn't under arrest until he was finally arrested, when he admitted to his first admission being to cutting Mr. Lind and taking the car and taking him to East Longmeadow and letting him go alive in a field, which of course ended up not being the case. He was informed he was free to leave. All of the indicia that this court traditionally looks at in terms of whether or not a situation is custodial. So I would suggest that the defendant has not met his burden.
Let me ask you, when the police officer identified those car keys as Lumina car keys, did that put the defendant in kind of a vulnerable position? Your brother is arguing, I think, that at that point in time,
That is, I believe you're right. That's the argument, that it was when confronted with that information. And I would suggest that at that point, a reasonable person would not believe that the situation had become custodial and that he was no longer free to leave. And I would specifically refer the court to its decisions in Commonwealth versus Murphy, Commonwealth versus Morse, Commonwealth versus Almonte, and particularly Commonwealth versus Groom, all of which are cited in my brief. And those are, by and large, those are all circumstances where, in one case, the defendant was asked for more specific information into it wasn't custodial. In Groom, the defendant was asked to come to the Cape and was to help in a missing car investigation. So the circumstances in those cases all compare favorably, and I would suggest that when Detective Dean asked him that question, it did not convert the confrontation into a custodial interrogation. And he didn't incriminate himself in any criminal activity anyway. He said, "I found the car and took it for a ride."
Well, that's a crime.
Well, the police didn't view it as such.
Well,
and I think that's the
because
testimony.
I mean, maybe they
well,
were
they didn't
fishing
know
for
that
bigger and better things.
Well, there was no claim of a stolen car, and I think that's what Detective Dean and Detective O'Shea both said, that there was no, there had been no report of a stolen car, so they didn't at this point view it as a crime. So I would suggest that that's kind of the linchpin of the whole argument in terms of the voluntariness of the statements and whether or not there's a taint. And unless the defendant meets that initial burden of showing that the interrogation at that point was custodial, then the rest of that fails. And I believe that the judge's findings support his conclusion in that regard. The claim of the coercive circumstances overbearing his will, I think I've touched on much of that. But I would also like to bring to the court's attention two cases in particular that I think support the Commonwealth's argument in that regard. In addition to, they're cited in my brief, and there are other cases cited, but I'm referring to the Jackson case and more recently the Morgan case, where a claim of psychological coercion was made. And in both situations, this court viewed the fact that the interviews were video recorded as information that rebutted those claims and allowed the judge to make the findings they did. And I would suggest that the same logic and same thinking would apply in this case. The judge made specific findings regarding his discomfort, his emotional state, and there was evidence that the defendant had an opportunity to sleep. Whether or not he took advantage of it was another question. And he was also offered food. He claimed he couldn't eat it because he was nervous. And he had coffee, cigarettes, and candy throughout the time that he was with the police. So I would suggest that the statements were voluntarily made. There's no question raised by my brother about the waiver of the Miranda warning, so the Commonwealth would view that argument as waived here. The Rosario waiver, I think the record is clear that the defendant twice signed a form waiving his rights and then in effect waived them once again when Detective Dean told him after he confessed to the murder around 10-something on Monday morning, we've got to get you to court, and he insisted upon accompanying the police to Munson to help find the victim's body. So I really don't think that there is a basis.
Do you think, I should know and don't know the answer to this. Does it matter? Is there when the waiver is given, in other words, should it have been signed before?
There was a signed waiver around 9 o'clock on Monday morning.
Right, but he's been there. But he's been there since Saturday night.
Well, he signed one on Saturday as well. Okay. He signed one on Saturday. Excuse me, one on Sunday and one. I'm sorry, I'm mixing up my days. Sunday and Monday morning.
But why? I guess that sort of begs the question: why didn't they start getting? Why did they get the form signed at 8:30 in the morning? At approximately the same time that would have taken him over to the courthouse.
On Monday morning, when Detective Dean testified that he went in, this is when he took the defendant out of the cell block, when he said he was cold, and he said, we've gotten some more information, and I'm paraphrasing here, but we've gotten some more information, and that's that your story doesn't add up in terms of there's not as much blood in the trunk as we would expect to find if what you were telling us was true.
But why weren't they driving him over to the courthouse at 8:30 in the morning on Monday?
Well, I think they had a right to ask him if he would give them another statement and if he was willing to.
They did that at 9. Why didn't they did it at 9?
I can't say why from not 8:30 as opposed to 9. There's really nothing in the record that would allow me to answer Your Honor's question.
But doesn't that fall on your shoulders? You've had him since Friday night.
Well, I think we'd have to get into the court isn't open for business at 8:30 in the morning.
It's not? I used to get there at 8 o'clock in the morning and they were there.
No, the sessions start at 9:30 in Springfield.
Don't you, but I think the point is, you've had him since Saturday night. I think it's Saturday night. And court is going to open on Monday morning, but instead of the first thing that happens to him going to court, he's actually giving a statement, and it sounds like he's giving the statement even before he gives the Rosario waiver. Is that right?
No, and it's on the video. He's given his Miranda warnings, and he signs. In fact, I should mention that each time he signs the Miranda waivers and the Rosario waivers, it's videotaped, and it was videotaped in the third. It was at the beginning of the third statement. It might actually be helpful to the court to watch the videos if you have questions about those things.
Didn't he sign the Rosario waiver for the first time shortly after he was arrested?
Yes.
And that was on the 9th.
Yes, the 9th Sunday, yes.
So, and then Monday morning, he signed them again.
He did.
Okay.
He did. And he had signed, and he had waived his Miranda warnings on numerous occasions. Judge Kinder, in his findings, said that the defendant expressed a desire to assist in the hopes of lenient treatment. I mean, there was this whole, there was a whole body of evidence that demonstrated his cooperativeness and his agreeability to, he was agreeable to doing these things. He had the option of not giving a statement, and he would have been taken to court, and Detective Dean testifies to as much about
That's when
Monday
he wanted
morning.
to go out looking for the body.
Well,
On Sunday,
Monday after the third statement,
Right.
which ended somewhere on the order of 10-something Monday morning. And
Went from 9
he
to
would have
11.
been brought to court to be arraigned around 10-something Monday morning had he not insisted that he accompany the police. And then that kind of brings us then to the situation where Attorney Brown goes to the Springfield Police Department and informs the detective in the Detective Bureau. He thought the defendant was at the Detective Bureau. He got there and he found out that the defendant was not in the building, that he was out in Munson, a community outside of Springfield, assisting the police. And it was a large, the evidence, the record evidence shows it was a large-scale operation. There were officers, law enforcement officers from many agencies participating in the search. What had happened was, prior to that time, the chief of police of Munson had gotten into the car with Detectives Dean and O'Shea and the defendant to help them, because he was obviously more familiar with, I think the evidence would show, were rural roads in Munson. And based on information the defendant had given to Chief Kozlowski, he actually mapped out areas to search. When the call came at 3, now at 2:48, he went to the police station.
He Barrett, or whatever.
Brown. The attorney went to the police station. Immediately, and I disagree with my brother on this, the testimony supports that the detective on duty immediately got to work trying to get a hold of somebody, but cell phone service was problematic, and he wasn't getting anybody on police radios. It was a rural area. He had some difficulties in locating someone. Captain McFarland calls the Detective Bureau. I think Attorney Brown testifies at 3 o'clock, roughly 10 minutes later. They have this conversation, and within minutes, Detective O'Shea gets the call in the car, and the information relayed to him from Captain McFarland is Attorney Brown's been appointed to represent the defendant, and he wants to talk to him. The phone is offered, the cell phone is offered, go ahead, call your attorney, he's been represented to appoint you. No, unequivocally, the defendant states he has no interest in talking to anybody until the victim's body is found, and he repeatedly emphasized that he wants to do this for the victim's family.
But they don't tell him that his lawyer says don't talk.
Well, Detective O'Shea relays the information that's provided to him, and at the evidentiary hearing on the motion to suppress, the transcript dated March 20th, 2009, at page 116, I think his testimony is helpful in this regard, because I think this is what takes this out of the McNulty case.
Whose testimony is this?
This is Attorney Brown's testimony.
Okay.
The Commonwealth
What's-
called him.
What's the site again, the transcript?
It is the 3/20/2009, page 116. The conversation, he admittedly informs Captain McFarland, among other things, that he doesn't want the police to question the defendant further. Captain McFarland explains that we're trying to locate the body. There's 1 hour of daylight left, and we're not coming back at this point. That he said we go back and forth. Ultimately, and this, I quote, ultimately what he offered up was, I will have the defendant call you. I can't have you speak to him right at this moment in the phone because he's not in the car with me. I will have the defendant call you. I ultimately accepted that, and I gave him my cell phone number. So I think it is fair, based on that evidence, to say that that was the agreement they reached. That was the information relayed to O'Shea, and the information that O'Shea relayed to the defendant.
And this was before McNulty was decided in any event, right?
Yes, it was before McNulty. McNulty was decided after the trial in this case. And I see I'm out of time, so I'll quickly wrap up. But I would like to mention that Judge Kinder found that the discovery of the body was inevitable in any event. I would otherwise rest on my brief and ask that the court give the parties an opportunity to brief the issue raised in the 16L letter if we feel it's necessary.
Thank you very much,
Thank you.
counsel.